And the first case is People versus Price, and this is an argument on the application. You have 15 minutes. You can try and reserve time. We'll try and help you with that, but you have to fight us off.
May it please the Court. For Dorian Price, I'm Douglas W. Baker of the State Appellate Defender Office. I would like to reserve whatever balance I have left for rebuttal, if there is a balance, and I welcome the Court's questions at any point. When the legislature enacted the felonious assault statute, it intended that a defendant would not be punished both for felonious assault and for assault with intent to do great bodily harm. We know that because when the legislature defined felonious assault in that statute, it defined it by saying that felonious assault was an assault made with a dangerous weapon without the intent to do great bodily harm or the intent to murder. That language means something. We both agree it does not mean that the prosecution bears the burden of proving that the defendant did not have the intent to commit great bodily harm. The defendant does not get a free pass if he's accused only of felonious assault and he's able to persuade the jury that his culpability was even greater. But it does have meaning, and the only plausible meaning is that the legislature intended for felonious assault to be an intermediate offense between great bodily harm above and simple assault below. That at least is the understanding that this Court has had for over 100 years. And the decision I cited in my brief, People v. Warner in 1918, considering a predecessor statute that used the same language, this Court said it was undoubtedly the legislature's intent to create such a scheme.
Counsel, I agree that the great Oxford philosopher or logician would look at those two statutes and reach a similar conclusion. But the obvious question, I think, is what is the significance of the language that provides that the two statutes are that if they arise out of the same conduct, they're both subject to prosecution.
Is Your Honor referring to 750.84
That's
sub
right,
3?
Part 3.
In which the legislature said this section does not prohibit multiple punishment.
What is we're trying to adduce, of course, what the legislature is saying. And I think it seems like they're saying something inconsistent in terms of the surface, the text of these two statutes. But then we have that complicating language in Section 3. Will you just help us a little bit better understand the significance of that language for what the legislature is attempting to communicate to us?
It's a superficial inconsistency, but the two statutes can be resolved. They can be resolved harmoniously by treating the sub 3 as a general indication that, as the statute itself says, this section does not prohibit. This section does not prohibit does not mean that another section might not prohibit. Section 82 here does prohibit. So this general admonition in Section 3 must yield to the more specific treatment in Section 82, the more specific statement of intent by the legislature. That is the way I think to read these two statutes in harmony.
What statute do you think was contemplated by that language?
Well,
if not the statutes involved in this case?
I don't know exactly, but we have to keep in mind that this happened, that this language was added to the GBH statute in effective April 2013. And it was part of a package of, well, first of all, subsection 2 was added. There had been no subsection 2 before. Subsection 2, which bars assault by strangulation or suffocation, was added, and then subsection 3 was added as well. And this was part of a general package of crimes treating domestic violence. I don't know what light that yields on sheds on what the legislature's intent might have been. I don't think, though, that it can be, we can assume that the legislature intended to affect the way the court reads subsection 82 or section 82. Does that answer Your Honor's question?
I appreciate your answer.
Counsel, would you agree that the mutually exclusive verdicts rule is not the proper frame for us to be thinking about the question that brings you here today, and it's really a question of whether the legislature intended for someone to be punished twice?
Well, I think that's the question that has to be answered with respect to any of these three possible theories of reversal. Ultimately, we have to know what the legislature's intent was. I don't really have anything more to say about that than that. I do, and I know fellow counsel has a lot to say about the mutually exclusive verdict rule. I would just add that with respect to the mutually exclusive verdict rule, I disagree with the prosecution's treatment of that rule in its brief. The prosecution suggests that Michigan doesn't recognize mutually inconsistent verdicts. One of the cases it cites in its brief, People v. Smith, actually refers to two statutes as being mutually exclusive. It doesn't apply the rule because it's not raised there, but certainly the Michigan courts are familiar with that concept. More importantly, the rule that says that inconsistent verdicts should not lead to relief is a majority rule, but not the rule that says mutually exclusive verdicts should lead to relief. There has been a conflation of those two rules. If you add them together, perhaps, and call mutually exclusive verdicts inconsistent verdicts, then it looks like there is a majority rule there. But I don't know of any cases that say a mutually exclusive verdict shouldn't lead to relief. But again, I think the important question here is not that, but whether there actually were mutually exclusive verdicts. Unless the court has questions at this point, I would reserve the balance of my time.
Thank you, counsel.
Thank you.
Good morning. May it please the court, Amanda Morris-Smith, Wayne County Prosecutor's Office. On behalf of the people of the state of Michigan, I would actually stand ready for the court's questions, and I want to get right to the issue at hand, which sounds to me like it's issue 2. And that is what I expected the court to be most interested in today. So to talk about the language in MCL 750-82 as compared to 750-84, Brother Counsel indicates that the only plausible meaning of the language in 750-82 is that the legislature did not intend these two statutes to be charged together. And I would say that this court should disagree with that, because in 1918, when the court looked at that same question in Warner, the court said it was undoubtedly the intent of the legislature just to create an intermediate offense. So 750-82, felonious assault, is an intermediate between a simple A and B and an assault with intent to do great bodily harm less than murder. And if you look at the sentencing penalty, that bears out, because felonious assault is a 4-year felony, AGBH is a 10-year felony. That understanding that the intent of the legislature was just to create an intermediate offense and to prevent the offense from falling within the higher offense, GBH, was also recognized with this court in doubt in 1923. So I disagree that the only plausible reading of the language in the statutes is that the legislature intended to create irreconcilable statutes so that they could not be charged together. As this court knows, the last expression of the legislature should control. And what did the legislature do here? Well, in 2013, they added Paren 3 to 750-84, indicating in the broadest possible terms that conduct charged under 84 could result in charging under any other statute. And in Miller, this court said just a few years ago, that type of language is a clear expression by the legislature to authorize multiple punishments. So to read the sub 3 of 84 as somehow not contemplating the language in 82, I think asks too much of that language. It's asking for an exception that is plainly not present on the face of that statute. And I gave many examples in the first section of my brief showing when the legislature intends to tell the prosecutor you cannot charge statutory pairs together, they clearly know how to make that known to the people and to the courts. And People versus Chambers, which is Michigan's Court of Appeals case, indicates that that's so. They know how to make it clear to us. And what did they do in 2013? They put sub 3 in 84, indicating in the broadest, again, possible terms, so we can charge any other crime and stack it with 84. So I just can't see how we can get around sub 3 when you read the statutory pairs together.
Well, you heard what opposing counsel said in response to my question. What is your response to him?
I'm so sorry, Justice Markman, could you remind me of your question?
I'm sorry?
Could you remind me of the question you asked Brother Counsel?
I asked him what the significance of Section 3 was.
As this court has indicated in Miller and in Shipley, the Court of Appeals said the same thing. That is a clear expression by the legislature to authorize multiple punishments.
Why wouldn't we think about it the way Mr. Baker said, that it clearly Section 84 may not prohibit a person from being charged with other crimes, but why does that tell us anything about what to do with the fact that another section does prohibit multiple punishments? So the negative element language in 81A and 81.2 appears to do just that. What do we do with that?
If I'm understanding your question correctly, so the court would be reading the language in 81A, when we'll talk about in Joel Davis, and 82 as indicating a signal of not intending to charge the two crimes together. And again,
punish, not
punish.
charge. Charging,
Okay.
I think, is fine. It's punishing.
Sure.
Right.
And again, this court said 100 years ago, that's not what that language means. And we have to read the statute within the context of when it was written, understand why did the legislature use this phrasing at the time it was written. I think Statute 8.3a indicates if a phrase in a statute has a certain meaning, a specialized meaning, that's what the court has to look at. And in 2007, this court also looked at a similar statute as far as the age and indicated that the important thing to consider for legislative intent is to look at or to understand the statute in the sense in which the words in the statute were meant to be used at the time the statute was written. So that's what I'm indicating here. Back when, for FA, the language that we're talking about, the without intent language, that's been in the statute since 1915. And it was always intended and always understood by this court going back 100 years. All of that was meant to signal is that it's a lesser offense. It's meant to distinguish it, to not collapse it into the higher offense. It is a separate offense. It's not meant to be read that it's creating like this negative intent language. That's exactly what Doss said as well. So I wanted to really emphasize that what the people are asking and what I tried to emphasize in my brief is that to be consistent with Doss and with this court's jurisprudence, we're just asking, I'm sorry. I'm so sorry. I wasn't sure. In any event, I'm just asking the court to follow 100 years of how this court has looked at this precise language, how it's been interpreted, and to understand that it's not meant to be a reconcilable intent language.
Is there any significance to the fact that the legislature in 84 included sub 3, but in 82, when it could have, didn't include that language? So while 84 may permit, I think as Justice McCormick said, you to charge under another statute, if the other statute doesn't permit it, and if the legislature obviously can show that it knows how to, put that permissive language in, what do we take from the lack of it in the other lesser statutes? Okay.
So 82 has not been modified anytime recently, so far as my research of that statute revealed. 84 was in 2013 when they added the strangulation language, and at that same time they added that Pren 3. This court said in Smith in 2007 that the Michigan Supreme Court and the United States Supreme Court has never held or never made it a rule that the legislature is required to indicate plainly on the face of a statute that multiple punishments are allowed. It's just not a rule that's ever been created or required of the legislature. So the fact that that language appears in 84 and not in 82 is not significant, or at least as this court understood that in 2007 in Smith.
Okay.
Is that something they could add? Sure, but it does not in any way change the analysis as far as reading those pairs together and looking at Paren 3 under 750-84.
Well, and I know it's not here in this case, but in the next, in 81A, it was amended at the same time, the 2013, and that language, similarly permissive language, wasn't added to 81A either.
Sure, and again, they're not required to add it.
Okay.
Would I, as a prosecutor, love them to put it in there? Sure. But this court and the U.S. Supreme Court has not made that a requirement. It's not recognized, and this court understood that in Smith. I'd be happy to talk about any of the other issues in this brief. And I know the court inquired as to double jeopardy in the first question, the mutually exclusive verdicts rule, which I know Justice McCormick asked a question about that. I could not find any Michigan case that recognized the rule against mutually exclusive verdicts. I could not. I know that there is a case, I think, from the Michigan Court of Appeals that indicated that by its plain language, the prosecutor cannot charge attempt murder with assault with intent to murder. And the language in those two statutes, when you read them side by side, it makes sense because it says very clearly it's conduct that doesn't amount to the crime of assault with intent to murder. So I think it was a case out of the 70s, the Court of Appeals said those statutes are mutually exclusive. You can't charge them together. And I couldn't find any case in which a prosecutor did go forward and charge them together. So the mutually exclusive verdict rule, which came out of the Joel Davis case, which we'll get to next, you know, it's a minority rule. Georgia kind of picked it up and ran with it. In my extensive research into this area, you know, Florida, Oregon, Maryland, these different jurisdictions will recognize it. But the key thing in all of those cases is that the question is not looking at the statutory language and comparing them. It's did the jury make irreconcilable findings? In no Court of Appeals panel, in this case, in the Joel Davis case, or in McEwen, which I filed as supplemental authority, has said or could say that the jury made irreconcilable findings in this case. The required elements for the jury to find for GBH and FA are completely distinct. There's nothing that conflicts between the two of them, and that's really the key for the mutually exclusive verdict rule. The jury has to make two findings of fact, positive findings of fact, that cannot be reconciled.
Seems to me the point, you referenced Warner and the negative element not needing to be proved, has some force when we're talking about mutually exclusive verdicts, but I'm not sure I understand your argument with respect to Warner on the first issue. Could you help me understand why that is not an indication that the legislature did not want there to be multiple punishments?
But this court said in Warner that that language is just a clear expression that it's a lesser offense, meaning that the mental state is different than GBH. It's just a different kind of crime. It's not a lesser included offense. It's meant to be charged separately, and a person could be punished separately.
So Warner says it could be punished separately, or that it could be charged separately?
Just bear with me one moment. So sorry. I'm looking here. The language I just have quoted from Warner is, it was just undoubtedly the intent of the legislature to create an intermediate offense between assault and battery and assault to do great bodily harm less than murder. And that court did quote to Sweeney from 1885, which made clear that the people are not required to elect between charges.
Yeah, that
So-
sounds like you can charge both offenses, which I don't think anybody disputes, right? But why does that get you across the finish line in your argument here today?
Well, Joel Davis, that published opinion from the Court of Appeals, said that the prosecutor erred by charging, in that case, the 751A and 754 together. And that same reasoning would hold true here because they contain the same language. So I'd argue that we do have an opinion from the Court of Appeals saying it's an error for the people to charge together, which I very much disagree with based on Sweeney. We can charge them together. We don't have to elect between offenses. And I'm sorry, what was the...
I mean, I'm just more focused on the multiple punishments issue that we're here, but I think is the issue before the court today, not whether you can charge them both.
So the double jeopardy question in question one?
Yeah, I just wanted to know if you had any more to say about Warner. But I have your brief up, and I saw the language there. So that's all.
Okay. Well, when it comes to, so if we're focusing just on double jeopardy, I would focus very much on Paren 3 of 84. It's a clear expression.
No, I got that. The
Right.
question is, we're sort of focusing you back to 82 and the language there, the negative element language, and I'm
Right.
trying to understand how much meaning we should give that, because it does give rise to an implicit conflict, right? That language, you're supposed to not, that's not supposed to be present, that element. Although the jury, you don't have the burden of proving or disproving the element, I suppose. But that's what the statutory language says, and we're trying to figure out what meaning we should give that language. And I'm just not sure Warner gets you very far on that issue.
I think I cited, well, I know that Brother Counsel really brought up Warner, and I responded to it in my brief. I just think that it's helpful because it indicates what that language was put in the statute for back when it came out in 1915, how this court read that language 100 years ago, and why in Doss, when this court looked at the without malice language, why this court decided that that is the term without malice simply means that it's you commit the crime, but the people don't have to prove malice. That's what it means. I mean, all of this kind of tracked back from Doss 40 years ago. This court just read that to mean that it's not something that we have to prove, and it doesn't mean the crime is committed without malice. It means that we don't affirmatively have to prove that at trial.
Can I ask, what do the people gain by retaining the conviction for the lesser statute? Or another way of saying, what do the people lose if that lesser conviction is vacated?
So a couple things.
Given the conviction on the greater statute.
Right. So, our goal as prosecutors is to charge and to hold a defendant to account for all of his actions, not just some. And in this court said in 2007 in Smith, that's what the Fifth Amendment allows us to do. And we are allowed to hold people to account for all of their criminal behavior and not just a selection of some. There's also a charging. May I finish the question?
Continue.
Thank you. When a prosecutor charges the case, we would charge everything that we reasonably believe we can prove at trial. We don't know what the jury will do. So, we could think we have a great GBH case and an FA case, and maybe the jury only picks one. Now, if the question is, I'm here today and I'm defending the FA conviction, I'm going to stand up for Joel Davis and defend that AG DV conviction, what does it really matter? To me, it matters very much because it's how the Court of Appeals is reading that statutory language and has far-reaching implications as to the integrity of our convictions throughout the state. As this court has seen in the cases I cited in my brief, McEwen most recently, People v. Williams, which was a larceny in a building and a larceny from a person, how the court reads the statutory language is going to affect our ability to charge and sentence defendants in the future. So it's significant to the jurisprudence of this state, not just significant to us as prosecutors wanting to hold a defendant to account for his actions. Okay. And I believe my time is up.
Thank you, counsel.
Thank you.
Mr. Baker, you managed to reserve some time.
A defendant is being held accountable for all his actions when he is convicted just for felonious assault or just for GBH. The question, what the prosecutor is seeking is the opportunity to hold him accountable twice for the same behavior. And the question is whether the legislature intended that. The legislature did not intend it with 82 because it said without the intent to do GBH, without the intent to murder. Justice Viviano, in response to your question, you can both say, as the court did in Warner, that you can't, that the prosecution is allowed to charge both offenses, and also recognize that you can't punish for both offenses at the same time. That's our position. We're not taking the position, as the prosecution seems to be assuming we are, that the prosecution cannot prosecute somebody for both GBH and felonious assault and let the jury decide what they will decide. The prosecution may also prosecute just for felonious assault, and as I said before, the defendant may not raise as a defense that he has a greater level of culpability.
Under your theory, they would be charged in the alternative?
They could be charged in the alternative, yes. Ultimately, though, the question, as Your Honor recognizes, is whether the legislature intended for the court to be able to punish twice. And here that clear expression of intent that they not be able to punish twice is evidenced by the language of 82 and recognized by Warner when it said that the legislature was intending a scheme in which there was a greater and a lesser offense.
I guess, Counsel, I'm not clear what the language does mean under your analysis. I mean, it says in 750.84.3, this section does not prohibit a person from being charged with, convicted of, or punished for any other violation of law arising out of the same conduct as a violation of this section. Of course, we always have to look at the other statute to see what it means. And I understand the surface inconsistency, the logical inconsistency that I suggested might be identified by the Oxford logician. But nonetheless, the language says what it says, and I'm trying to understand, given that this language came after the enactment of the other two statutes, what conceivably the legislature would have intended except to defeat the double jeopardy argument that's raised precisely in this case. Of course, we always look to the other statute. It's never this section that precludes us from looking to the other statute, but why would this language be in there if it wasn't meant to preclude a double jeopardy claim, even when the other statute seemed to suggest there might be a double jeopardy problem of some sort?
Well, the court always looks to the other statute because case law says the court must do that. The legislature might here be saying, in case the case law ever changes, we want to make it clear for ourselves, make it clear on the face of the statute that the court ought to do that. In other words, in case Blockberger goes away, in case Green goes away.
Real world impact is, I guess, what I'm asking. Section 3, why was it enacted and where would it have some real world impact in precluding a double jeopardy claim that might otherwise exist? It seems to me the language arising out of the same conduct certainly seems to give reference to traditional understandings of double jeopardy analysis. Why would the legislature have put this provision in the statute, and where would they have anticipated it would have had some effect?
When the court looks to the other statute and sees no indication, no countervailing indication that the legislature did not intend for multiple
Then why would they need it if there's no indication that there's a double jeopardy claim in the first place?
Well, because double jeopardy claims are brought by defendants sometimes when there seems to be no real good, solid argument for it. But also, as I said before, the legislature could be saying, we're going to make it clear our intent for the record, even though we don't need to do that right now under the existing case law, in case the case law changes.
So this means there's no double jeopardy claim in a dispute in which there's no real double jeopardy claim.
Maybe you look to another statute and there's no expression of intent, and then there is no double jeopardy claim. I hate to bring it up because I might be arguing the other side eventually, but with assault with intent to murder, if the prosecution is right about the language here, assault with intent to murder and assault with intent to do great bodily harm less than murder could both be punished. According to the prosecution, subsection 3 of 84 would permit that.
But I think once we look at the second statute and we're not sure whether or not a double jeopardy claim is implicated or not, we then have another test that's designed to determine whether or not the legislature really intended that double jeopardy apply or not apply, and that's the Blockberger test, right? And you apply the Blockberger test here, and I think there are distinguishing elements in these two statutes, so you probably would lose on that ground.
Correct.
But I'm curious about this threshold determination that comes from the language of Section 3 in light of these two statutes that I acknowledge seem to be incompatible with each other, at least in a cosmic sense.
The real world impact, again, the court must look to the other statute if there is no express provision.
You always have to look at the other. There's always another statute if there's a double jeopardy claim, right?
Correct.
Okay, and you're saying if the other statute suggests that there is a double jeopardy problem, then this language is meaningless. And if it suggests there's no double jeopardy problem, the statute is equally meaningless.
I'm not suggesting that it's meaningless. I'm suggesting that the court or that the legislature may have put that language in there as a safeguard against the possibility that in the future there will not be a Blockberger test to guide the court. And this expression of intent will serve as a substitute.
So you think this language avoids us having to invoke the Blockberger test in those cases in which the legislative intent is not otherwise made clear?
That is certainly one intent, and it avoids the court having to contradict the intent evident in the other statute and allows the court to read the two sections harmoniously, which I think ought to be the court's purpose.
If there are no further questions,
May I just add one more word about Miller?
you have 48 seconds. You sure can.
It won't even take that long. Miller is a different case because in that case the court was construing a subsection of the statute to shed light on the rest of the statute itself. It was not looking outside the statute as the prosecution is asking the court to do here.
Thank you,
Thank you.
counsel.